Hey guys, welcome back. Today we're revisiting a sovereign citizen case that seemed forgotten for months, until the court finally delivered its long-awaited conclusion. And while the outcome itself wasn't the biggest surprise, the judge's reaction to the defendant's unbelievable answers absolutely was. What started as a routine hearing quickly turned into a courtroom moment that had everyone paying attention, making this ending far more entertaining and memorable than anyone could have expected.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written, on the envelope itself, it had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
We attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
And honestly, what does freeze even mean in this situation? The logic falls apart the moment you think about it. Simply writing a few words on the outside of a discovery packet doesn't magically make it disappear or invalidate it. If anything, it only draws more attention to the refusal to deal with reality. Instead of solving the problem, it turns the denial itself into the most noticeable part of the entire situation.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not.
And what exactly did he think was inside that packet? Refusing to accept your own discovery is about as self-defeating as it gets. It doesn't make the case disappear, it just leaves you completely unprepared for what's coming. No knowledge of the allegations, no understanding of the evidence, and no clear picture of what the prosecution plans to present. At that point, you're not building a defense, you're walking into court blindfolded and hoping for the best.
They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. She
I'm
cut
going to
me
mute
off.
you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
going to have this.
Talking.
This is not a clown show.
Oh
You
my
will speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes,
Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
Honestly, that part isn't hard to believe at all. Based on everything we've seen in this case, the pattern is pretty clear. Simple decisions keep turning into bigger problems, and opportunities to help the situation seem to make it worse instead. At a certain point, it stops being surprising and starts becoming predictable. And seeing that same pattern unfold in a courtroom only makes the entire situation even more remarkable to watch.
I'm muting Mr. Hurst, and I will let Ms. Strickhardt say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhardt, you were responding to Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
Trust me, sovereign citizen ideology often becomes a financial disaster waiting to happen. It has a way of turning ordinary decisions into costly mistakes, creating confusion where there should be clarity. Most financially responsible people see the warning signs early and keep their distance, because once someone fully embraces these beliefs, the problems rarely stay small. They tend to grow bigger, more expensive, and much harder to escape.
I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have.
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date, and sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules will cut against you, then so be it.
At some point, the responsibility falls entirely on your own shoulders. If you keep making choices that undermine your position, the court isn't going to step in and rescue you from the consequences. The more the situation unfolds, the clearer the pattern becomes, and before long, even the judge may view the entire spectacle as a lesson in what not to do. By then, the outcome is no longer surprising. It's the result of decisions everyone saw coming.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she have to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Strickhardt?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Do you should they have sent me something before they sending me this package since the last court date
Sir,
to verify that?
sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay, so she's gonna send me a packet and I'm gonna send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again. We had this conversation before, didn't we?
Sorry.
We
Go
had
ahead.
this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as her.
In the end, he found himself in the same position, except without the legal knowledge or courtroom experience that might have helped him navigate the situation more effectively. And that gap became impossible to miss. After all the objections and resistance, he finally accepted the packet, bringing his first court appearance to an end. But the real story is just getting started, because when he returns for his second appearance, the situation takes an even more unexpected turn.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Taking time for pretrial, your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
He's about to come face to face with the consequences of every decision that brought him to this point. And now we've finally reached the moment this case has been building toward from the very beginning. What happens next goes far beyond a routine court hearing. The judge's reaction to the situation turns the entire exchange into one of those rare courtroom moments that feels almost impossible to predict, yet impossible to look away from.
All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contained or contains no elements of fraud by Credit One Bank. Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the courtroom, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
And somehow, the moments only get more memorable the deeper you get into the case, making it one of those courtroom clips that stays entertaining no matter how many times you watch it. With that, we've reached the end of today's video. If you enjoyed the breakdown, be sure to leave a like, and if not, feel free to let me know. Either way, drop your thoughts in the comments, and don't forget to subscribe and turn on notifications so you never miss the latest courtroom drama and unbelievable legal moments featured on the channel.